Okay, good morning, and thank you very much for joining us today. My name is Lindsay Robinson, and I'm an associate specialising in construction and engineering dispute resolution at Shepherd and Wedderburn. I'm also joined today by my colleague, Sean White, who is a solicitor in our team. Our team regularly advises clients in respect of construction contract issues and disputes across a range of projects, and our team is experienced in assisting our clients with all forms of dispute resolution involving litigation, arbitration, adjudication, and mediation. So I'd like to welcome you to the first of our two-part webinar series discussing two significant pieces of legislation which have come into force in 2022. Today's seminar will look at the changes brought in by the Prescription Scotland Act 2018, which has partly come into force in June this year. The second webinar will look at the Building Safety Act 2022 and the implications for construction projects. In this series, we will examine how these two laws have developed and what these changes might mean for your construction business in 2022 and beyond. The webinar today will focus on the law of prescription in Scotland. As many of you will know, prescription is when obligations are extinguished after a period of time and is similar to the legal principle of limitation in England. Today, we will look at how prescription has changed in recent years, including looking at some of the key court precedents. We will highlight the main facts and legal points from each development and identify specific lessons to be aware of for construction contract claims. If you'd like to ask any questions today, please do so by using the Ask a Question tab, which should be at the bottom of your screen. In order that we can keep time, we will be answering as many questions as we can at the end of the presentation rather than as we go along. So if we don't manage to get to your question, or if you're listening to a recording of this webinar, please do get in touch, and our contact details are provided in the slides. So now I'd like to pass you over to Sean.
Thank you, Lindsay. So turning to the agenda for today, we will start by introducing the purpose and features of prescription and explain why it is an important legal tool for providing certainty and removing an indefinite risk of litigation. We will then provide an outline of the Prescription and Limitation Scotland Act 1973, which is the main piece of legislation containing the rules on prescription. We will look particularly at the point in time from which prescription starts to run and for how long. And in doing so, we will consider the Supreme Court decision in the case of Morrison against ICL Plastics and others, which fundamentally reinterpreted the legislation insofar as it related to the date from which prescription starts to run in cases concerning latent damage. We will then look at two further decisions in the cases of Gordon's trustees against CRBP and Midlothian Council against Blythe and others, where this interpretation was further developed and led to harsh outcomes for the pursuers in each case. Finally, we will turn to consider the newly enforced Prescription Scotland Act 2018, which seeks to address the perceived unfairness in the rules on prescription which has developed, and also introduces the option of using standstill agreements in Scotland. To begin, we consider what is prescription. In short, prescription is a legal principle found in statute which enables obligations to expire or prescribe after a period of time. Practically, this means that those with the right to enforce payment, contractual performance, or some other legal obligation lose that right after a period of time, following which it is extinguished and any claim subsequently brought will be considered to have time barred. As we shall see, the length of the prescriptive period can vary depending on the nature of the obligation, i.e. whether it relates to a breach of contract, reparation, property rights, etc. For most known obligations in Scotland, the prescriptive period lasts for 5 years, and generally it will run from the date on which damage, injury, or defect occurred. However, the beginning of the prescriptive period is capable of being postponed in situations where a party is not aware it has suffered loss and could not reasonably have been expected to have been aware of it. This has become known as the discoverability test. In today's webinar, we explore the law of prescription in Scotland, how it has developed over recent years, and the implications of those developments for our clients. Although today's discussion will focus on prescription, it is important to note that this is subtly different from limitation in England. Whereas prescription extinguishes an obligation, With limitation, the obligation lives on, but the litigant is barred from seeking to enforce it. Functionally, however, these are the same. So turning to the basic principles, what is the purpose of prescription? The basic idea is that it protects people and businesses from being challenged with historical claims. Litigating old or obsolete claims would be unfairly disruptive, and evidence will likely be scant and unreliable for all parties involved due to the passage of time. Prescription fundamentally is about moving forward. Certainty is essential for business confidence, investment, and general progress. Additionally, prescription may act as a penalty for would-be litigants who have sat on their claims, either through negligence or opportunism. It encourages parties to raise court proceedings promptly, so that disputes can be settled in a timely manner. Those who fail to pursue their claims are presumed to have abandoned them. In this way, prescription is an incentive for people to look after their property and interests with good diligence. Undergirding prescription is the public interest of legal certainty and leaving the past behind. Prescription ultimately is about practicality as much as it is about justice. And here there's a balance to be struck between achieving fairness for wronged parties and recovering their loss, and assuring clarity and progress for the wider public. As we talk through the changes to the law on prescription, do please keep this in mind and consider whether the correct balance is being struck. I'll now pass you back to Lindsay to talk about the 1973 Act.
Thank you. So the Prescription and Limitation Scotland Act 1973 consolidated the rules on prescription in Scotland. Briefly, the Act provided two prescriptive periods for various types of obligations. Short negative prescriptive periods of 5 years occur for obligations relating to money, contract or delictual claims under Section 6, and long negative prescription periods of 20 years, mostly for specific property rights under Section 7. Some rights are known as imprescriptible and include heritable ownership, leases, and certain trustee obligations. It's important to be aware, though, that there are other Acts of Parliament that have introduced different prescriptive periods for specific matters. For example, loss of aeroplane cargo prescribes after 2 years, and many tax claims prescribe after 4 years. Equally, if you're an employee raising a claim for unfair dismissal, you only have 3 months to raise a claim. For today's talk, however, we're going to focus on the 5-year period relevant to contractual obligations. Please note that in England, the equivalent term is 6 years for a contractual obligation, and this has caught out many a person unfamiliar with Scots law. An essential task is identifying the point at which the prescriptive period starts to run. The normal rule, according to Section 6, is that it starts when the relevant legal obligation becomes enforceable. For instance, an example would be if an invoice was due to be paid but payment was not received, a contractual obligation, the prescriptive period would begin from the date the payment was due. For a delictual claim, i.e. negligence, if a wrecking ball struck your property, the Negligent Act, you would have incurred loss at the same time as that negligent act, and that would be when the prescriptive period began to run. However, it is not necessarily when the original negligence took place, rather it is when the loss arising from that actionable wrong comes about. When one negligent cause leads to multiple events of damage, the clock runs from the first damage. This means that in a building contract where several defects emerge, we must treat each of these defects separately, noting when the damage occurred and which exact defect caused it. However, the 1973 Act provides an exception to this normal rule in respect of latent defects, in cases where defects may lie dormant for a number of years before it materialises. Section 11.3 allows for the prescriptive clock to be delayed where the damage or loss is not immediately apparent. In such cases, the clock starts ticking when the party who has suffered the defect discovers the damage, known as the discoverability test, or when they could have become so aware through reasonable diligence. Reasonable diligence will depend on specific circumstances, but it is about taking the steps an ordinary creditor would take to look after their personal or commercial affairs. In some cases, the creditor may need to justify why they didn't take steps to become aware. It goes without saying that keeping detailed records of your meetings or interactions with your suppliers and customers is essential for protecting your business interests in the event of a latent damage claim. We're going to return to the discoverability test shortly, as it has become the main battleground in recent prescription cases. However, we want to talk about how does a party stop the prescriptive clock? The simplest way is by making a relevant claim, which in most cases means starting court proceedings. However, prescription can also be stopped through a relevant acknowledgement, which involves the wrongdoer acknowledging the claim. In all cases, it is prudent to obtain legal advice as soon as possible to avoid the right of a claim being lost through the passage of time. For 30 years, this discoverability test and the knowledge of loss had been a settled position by the courts. For the start of the prescriptive period to be delayed, the party at loss had to be ignorant of, firstly, that the loss or damage had happened, and secondly, that this was caused by a legal wrong. However, judicial decisions in recent cases threw confusion at this long-established doctrine, and I'd now like to pass you back to Sean to discuss the case authority.
Thank you, Lindsay. So we will look at three cases, and the first one I'd like to look at is Morrison against ICL Plastics and others. So over 40 years after the introduction of the 1973 Act, the UK Supreme Court considered the interpretation of the discoverability test set out under section 11.3 of the Act and flipped the position as it was previously understood to be on its head. In August 2009, the pursuer, Morrison, sued a plastics company, ICL, for damages following an explosion in the latter's factory. The explosion occurred in Glasgow in May 2004, killing 9 people and damaging neighbouring properties, one of which belonged to Mr. Morrison. The defender, ICL, argued that Morrison's case was time-barred, since the damage occurred over 5 years prior to the action being raised. But Morrison pled that since he was unaware that the explosion had been caused by a wrongful act, his claim had not prescribed in terms of section 11.3. He had only taken action following publication of a report in July 2009, which identified ICL as being at fault for the explosion. Although Morrison's understanding of discoverability was in line with Scottish precedent and legal thinking at the time, the Supreme Court reached a different view, and by a majority of 3-2, they held that the prescriptive period ran from the day on which the pursuer became aware that the damage or loss had occurred, and whether they knew that this damage was caused by an actionable wrong was irrelevant. In reaching this conclusion, the Supreme Court was concerned largely with statutory interpretation rather than the broader principles of prescription. In any event, the consequences of this ruling were significant, and subsequent cases demonstrate some of the difficult results that would follow by applying this interpretation. Turning then to look at Gordon's trustees against CRBP. CRBP were a law firm based in Milngavie, and this was a case of financial loss flowing from a breach of contract as opposed to one concerning delictual damage to property. In 2004, upon receiving instructions from Gordon's trustees, CRBP served 3 notices to tenants of the trustees' farmland requesting that they vacate the property. However, the tenants refused to do so. In 2006, the trustees applied to the Scottish Land Court to have the tenants removed, but the court found in 2008 that 2 of the 3 notices issued by CRBP were invalid. In May 2012, Gordon's trustees raised proceedings against CRBP for breach of contract, but CRBP argued that any obligation to compensate for losses had prescribed. Although pre-Morrison, the prescriptive period might have been taken to have commenced in 2008 when the negligence was established, the Court of Session followed Morrison and held that the prescriptive period began to run in 2006 after the farm tenants failed to vacate the property in accordance with the terms of the notices, and the pursuer had incurred expenditure seeking to enforce those notices in the Land Court. This all occurred 6 years prior to Gordon's trustees having raised proceedings against CRBP, and accordingly their claim was out of time. Importantly, the court held that it was irrelevant that when they were incurring legal fees, the trustees were unaware they would ultimately suffer a loss. The decision was appealed to the Inner House of the Court of Session and eventually to the Supreme Court, but both courts upheld the decision of the Outer House. Turning to look at the final case, which is Midlothian Council against Blythe and others. In 2004, Midlothian Council was planning to build social housing on a site above a former coal mine. They employed Blythe Blythe to investigate the site in order to determine whether there were any safety concerns. Blythe reported that the risk of ground gas was low, and based on this advice, Midlothian Council built 64 houses without including a protective membrane underneath the development. Construction was completed in 2009. However, in 2013, harmful gas was identified on one of the properties, and the council was forced to demolish the estate. It commenced proceedings against Blythe in 2018. The council argued that the prescriptive period began to run from 2030, when it first became aware that the development was uninhabitable. However, the court abided by the decision in Gordon's trustees and found that the relevant date for commencement of the prescriptive period was 2004, when the council acted on the defender's advice. The relevant loss was the expenditure incurred in building the development. And this is a prime example of a case where the pursuers lost its right to recover losses before it was even aware that it had suffered any loss. The decision in Midlothian Council was very controversial, and concerns began to grow that the balance of fairness was tipping unduly in the debtor's favour. However, change was on its way, and I'll pass you back to Lindsay to talk about the Prescription Scotland Act 2018.
Thank you. The Scottish Parliament were persuaded that the interpretation of prescription law had moved too far in favour of the debtor. So they decided to act, and the Prescription Scotland Act was passed in 2018, with some of its provisions coming into force in June 2022 and others being due to come into force in 2025. The purpose of the 2018 Act was to bring greater clarity and certainty to prescription and to reset the balance of fairness between debtors and creditors in the public interest, and also it introduced standstill agreements into Scots law. The two main changes that are in force so far are first, the discoverability test in the 1973 Act has been changed. Under Section 11.3, this allows for the prescriptive clock to be delayed in certain circumstances. The amended 1973 Act lists the facts which the pursuer must know or could find out with reasonable diligence to allow the pursuer to rely on Section 3. And these are the following: that the loss, injury or damage has occurred, that the loss, injury or damage was caused by a person's act or omission, and the identity of that person. Furthermore, the 2018 Act clarifies that it is irrelevant whether the creditor knew that the cause of the damage or loss was actionable in law. The amended legislation provides much needed clarity to the area of latent defects. However, it's going to be interesting to see how the amended discoverability test will be interpreted by the courts. It's clearly intended to offer greater protection to would-be pursuers in cases of latent defects. Future latent defect claims should now be able to steer away from the decisions in Midlothian Council where the parties bore a loss before becoming aware of it. In this way, the 2018 Act has turned the clock back, returning to a pre-Morrison against ICL position. Given the changes, we can expect to see increased litigation as the balance of claims being in time has now swung greater in favour of pursuers. Importantly, however, the new discoverability test is not retroactive, and already prescribed claims will not revive. Yet for old latent defects whose cause and culprit are yet to be identified, whether the prescriptive period ends on the 31st of May or the 1st of June 2022 could make a great deal of difference. Despite the changes in the law, it's prudent to take active steps to protect any right to a claim by seeking advice and either raising proceedings to stop prescription or entering into a standstill agreement. Now I'll push back to Sean.
Thanks, Lindsay. Yes, so the second major change introduced by the 2018 Act was the introduction of standstill agreements in Scotland. A standstill agreement is a formal understanding between parties to extend the prescriptive period. Those familiar with the equivalent laws in England, where the use of such agreements have been commonplace for some time, are often surprised to learn that they were not previously available in Scotland. But these were introduced under Section 13 of the 2018 Act, which entitles parties to enter standstill agreements to extend the prescriptive period. However, the same degree of flexibility afforded in England is not available in Scotland. The legislation provides that standstill agreements can be entered into only during the prescriptive period, and only a single extension will be allowed for a maximum period of 1 year. Of course, whether a standstill agreement is a viable option in any given case will depend upon both creditor and debtor reaching agreement on its terms, which may not always be achievable, particularly where time is of the essence. Nonetheless, introduction of standstill agreements in Scotland is a welcome change. The primary advantage is that they may be used to postpone the commencement of costly litigation and allow parties some breathing space in order to seek to resolve their disputes out of court. They may also provide an opportunity for business partners to better preserve their cooperative relationships. Many would prefer to sign an agreement rather than be served with court papers. Before new legislation came into force, pursuers required to press ahead with litigation in order to preserve any entitlement to claim, but now there is scope for more collaborative solutions. Notwithstanding the benefits, standstill agreements also carry risks. Poor drafting or attempting to conclude agreements too close to the end of a prescriptive period could be fatal to the would-be pursuer's claim. To mitigate these risks, parties should be mindful of the prescriptive periods and seek reliable legal advice at the earliest opportunity. So before we turn to answer some of your questions, I just want to conclude and offer the following practical tips. Firstly, we might expect an increase in litigation of cases concerning latent defects as a consequence of the new Act. Parties with access to old files, photographs and witness evidence will be at a significant advantage in pursuing or defending such cases. Accordingly, thought should be given to how best documentation might be preserved in order that it may be referred to in the event that a claim or dispute arises. Secondly, consider entering into standstill agreements where appropriate. All parties involved could save time and money by avoiding litigation while preserving goodwill in their business relationships. However, be sure to seek legal advice early and commence negotiations in plenty of time prior to the prescriptive deadline. Thirdly, establish systems and practices by which proper due diligence is undertaken in all of the company's business dealings. We expect to see more claims being defended on the basis that the debtor ought reasonably to have identified the relevant facts to pursue its claim at an earlier date, and so it will be important to preempt this line of defence. Fourthly, please be aware that many cases involving latent defects will still be determined in accordance with the old law, that is, the law as it was prior to the provisions of the 2018 Act coming into force. Where loss occurred prior to June 2017, any claim may well have time barred, even if knowledge of the loss has not arisen until a later date. It will be important to fully consider the prescriptive periods applicable in any given case. Finally, keeping up to date with developments in the law concerning prescription is going to be worthwhile. We expect there will be decisions commenting upon the correct interpretation of the 2018 Act in the coming years as the courts begin to grapple with the relevant provisions. If in any doubt about how any such developments might affect your business, then please seek timely legal advice. We'll now look at some of the questions that some of you have posed.
Thanks, Sean, for that really helpful summary. So we'd like to offer you the opportunity to ask us any questions in the question and answer function at the bottom of your screen. So please do so. We've got one question to begin with, and that is, do you feel that there will be an uptake in the use of standstill agreements in Scotland? And to answer that question, I can perhaps just give some experience of my working role at the moment. We have been asked to draft at least 3 standstill agreements since the legislation has come into force. And I feel that certainly for clients, there's a huge benefit in the use of standstill agreements in Scotland. In particularly clients that are familiar with using them where they are involved in English litigated cases. And the reasons for that are really as follows. I don't think it can be underestimated the damage that raising a court action can have, mainly in terms of any kind of commercial relationship. And the reason for that is particularly that once a court action is raised, it means that there's an obligation on a business to, in terms of their reporting line and auditing. So avoiding claims being raised can be is a real benefit to a business. So if a standstill agreement can be utilised to just allow that little bit of breathing space for commercial negotiations to continue, if there's any pinch points or pressure within the business, they can be really useful tools. Conversely, however, and certainly from the legal side, I think that we want to protect a client's interest, and to be absolutely certain of doing that. Raising proceedings is an option that we've been comfortable with for many years. So I really think that you have to give it detailed consideration at the time, and whether a standstill agreement is the best option for your business at that moment. Sean, would you have anything else to add?
Completely agree with all of that, Lindsay.
Okay.
I mean, standstill agreements won't be appropriate in every single case, but certainly I've been finding that I have been advising clients to consider them as an option in the majority of cases, particularly where there is an ongoing relationship between the debtor and creditor, in order to preserve that. I mean, I think, as I touched upon earlier, I think asking another party to sign an agreement puts far less pressure on a relationship than serving them with court papers. So yeah, no, absolutely. And I think probably we will likely see more and more standstill agreements starting to be used.
Great, thank you. And the other question that we've had is, how do you think the court will approach the new amendments? So personally, I welcome the changes. I think that the amendments do strike the right balance of fairness between parties, and we will obviously be keeping an eye on any new decisions that come out that address prescription in future. My gut feeling is that I think that the need for the changes were apparent, and that the judiciary may have some sympathy with pursuers when considering the old prescriptive law in future. However, we can't be assured of how they're going to approach prescription in future, so it will be really interesting to see the decisions as and when they come about. Sean, would you have anything further to add?
No, not really, Lindsay. I mean, I think, yes, time will tell. We will see what the courts do with the legislation, but certainly I think we should see a return to the pre-Morrison position, but we will only know when the courts have had an opportunity to look at the provisions.
Great. That's great. In that case, I just want to thank you all for attending today. This is a recorded webinar, so you will be able to look back and watch it again. And just thank you very much for joining us today. And we'd like to offer this invitation for you to join us again for our next seminar, which is happening on the 14th of September for the Building Safety Act. Thank you very much.